Good just afternoon, everybody. It's very nice to see you here. I just wanted to point out that this is really a discussion of arbitrary detention with perhaps specific reference to one case, Masha Lazareva. But it's a more general issue than just one person, as we all know, and the panel here that we have has been selected really for its extraordinary range of experience in different countries and different jurisdictions and administrations. Let me just introduce the panel first of all. Cherie Blair is the founder and chair of Omnia Strategy LLP, and we're advisors on international dispute resolution, the rule of law, corporate responsibility, and human rights, all the kind of good things, you know. She's famously an international lawyer, Queen's Counsel, and it may not entirely have slipped your notice that she's also the wife of the last British Prime Minister who didn't leave under a cloud. François Zimmeret is a leading international lawyer, formerly the French Human Rights Ambassador at Large. He's conducted more than 100 field missions, I think, related to human rights issues, mostly in conflict or post-conflict zones. Max Andenas here, Professor of Law at the University of Oslo and at the Institute of Advanced Legal Studies in London. So he's a barrister in London and an advocate in Norway. He's been President Rapporteur on the UN Working Group on Arbitrary Detention from 2009 to 2015, and he's successfully intervened in the Belhaj case in the UK Supreme Court, and I gather you're also involved in the Carlos Ghosn case in Japan, which I think we'd be interested to know more about as well. Randa Fahmy, internationally recognized expert on global government affairs, energy policy and national security. She has more than 30 years experience in legal and public policy, including service in the executive and legislative branches of the US government. So this is, as you can see, a really, really high-powered panel. I am merely the World Affairs editor of the BBC, which sounds terribly grand, but seems to mean less and less nowadays. Now, I'm going to be a bit of an Obergruppenführer on this because we've got a deadline. We have to get out of this building at a certain time. So what we're going to do is I'm going to ask the panelists for their views on the issue of arbitrary detention and in particular on the case of Ms. Lazareva, which I'll just mention briefly in a second. And I'm just going to ask them to talk for a few minutes each. I've got, this is the only timepiece as far as I can see in the room, and it's the one I'm going to go on. So I will have to kind of cut you short if you don't mind, because we do have a bit of a deadline. The case of Masha Lazareva is quite an appalling one. Somebody coming to, I mean, I've read about it in the newspapers. I haven't studied it particularly. I felt it was slightly out of my field. But she's one of Russia's most successful businesswomen. She's the only woman to have headed a major investment company in Kuwait, which is really quite an important distinction. Until, that is, the Kuwaiti authorities, out of the blue, accused her of stealing $500 million. Now, it's not my case. I've spent a lot of time in Kuwait. I've had troubles of my own with the courts and the police and so on, but nothing to do with corruption or anything like that, or having crossed a border at the wrong place. But I know how difficult these things are, and how really the mood of the individual official that you deal with, or the individual judge or the individual policeman can absolutely guarantee the conduct of the way that you will be treated. And if you're lucky and you get on well with the guy and you leave with a handshake, and if you're not, as happened in my case, you get you're under house arrest, your passport's taken away from you, and directly gets to be the summer, and it gets to be the summer rather quickly in Kuwait. You ring up day and night on the numbers that you're given, and nobody ever answers. And I can only have a faint notion of what Marsha must have been through. The case, the trial was absolutely outrageous in many ways. It relied almost entirely on the testimony of a single witness from the Kuwait Audit Bureau, who presented documents which were later found by a separate court to have been forged. She was refused bail when other defendants were given bail, and then when bail was set, it was for a grotesquely large amount, $65 million. It was whittled down eventually to what is, by any standards, a large amount, $3.3 million. But even when that was paid into court, and there was never any question that she would escape because she's got a 4 or 5-year-old child, the Kuwaiti Attorney General refused to let her out of prison. She spent altogether 472 days in Sulaybia prison, which is it's a byword in Kuwait for being really unpleasant. Overcrowded, and you can imagine what conditions are like during the summer. And she was sentenced to 10 years hard labour. Her fellow defendant, Saeed Dashti, was sentenced to 15 years hard labour. I mean, that really boggles all imagination. And, you know, I mean, it really was a travesty. And Lord Carlisle of Berriew, QC, wrote in the Times newspaper in London, there is no evidential basis to justify any claim of dishonesty, corruption, or any other criminal wrong. And he went on, and this is something I think we ought to touch on here. He added, anyone thinking of doing business in Kuwait should read this case with mounting concern. Anyway, there we are. That's my two penneth. I'd like, first of all, to go to Mads to just outline what arbitrary detention means and how serious it is globally. Those kind of issues. Would you do that, bearing in mind my terroristic watch? Yes.
Well, arbitrary detention is perhaps the most serious and widespread human rights violation of the classical kind. The authorities detain somebody in a prison or some other way, and without following the due process requirements that international law lay down, and of course every national system will lay down as well. So in the International Covenant on Civil and Political Rights, in Article 9, there's a prohibition against arbitrary detention. And what you described in Mr. Lazareva's case is, of course, an arbitrary detention. And why is it an arbitrary detention? Well, because she was not charged, she was not given the right to appeal. There are a set of issues about the later trial, which then on their own, and of course seen together, would make her case one of arbitrary detention. Now, when this topic we're talking about here today, the risk of conducting business abroad, when you're thinking about detention, you're thinking about the political prisoner. So that's, of course, what the international bodies very much have worked with. But now when you have a new business environment where you have public procurement rules, you have state aid rules, letting foreign competition in and making it more difficult to resist, or you have international companies merging with different national factions, that one side then go to their authorities with a case and say, this man is guilty of corruption, this woman is guilty of corruption, other kinds of fraud. well, that becomes a new issue, a new matter of concern. And somehow, there's no doubt today that arbitrary detention becomes an instrument in business fights. And of course, this is problematic from an international point of view, from a rights point of view, but also from an international trade point of view. Now, the International Court of Justice had its first case on arbitrary detention 6 or 7 years ago. And that was the case of Diallo, and that was a businessman in Congo who was detained. And it's about business and a businessman who's detained for business reasons, competitors and the authorities ganging up. And they held this was an arbitrary detention, and they gave him a right to compensation. Now, in the UN, you have, in addition to the International Court, which is a body for complaints brought by a state against another state, in the UN system you have several mechanisms where individuals can bring complaints. And that's, for instance, the Human Rights Committee, which is the treaty body for the International Covenant on Civil and Political Rights. And then you have the specialist body on detention, the Working Group on Arbitrary Detention, which I chaired for a period. And that's the specialist body of the UN on detention. And of course, there again, it was the political prisoner. It was the Amnesty International prisoner, which was the starting point, the paradigm case. But then we've seen recent cases, for instance, from Venezuela and Cuba, where there's a businessman who is, for political reasons, pursued for corruption, for tax evasion. Now, this, of course, continues in a whole range of situations. And the Working Group on Arbitrary Detention will then look at, did the person, the detainee, go before a judge within a certain time frame, no more than 48 hours? Was this an independent judge? Did he have counsel? Could he communicate, he or she communicate freely with their counsel? Then what happened in the next round? Could they challenge their detention? And what went on in the later case against them in terms of these basic procedural guarantees? And then, if there is a question of, say, the right of expression, political expression, religious issues, there's a higher threshold for the international. The international review will set a higher threshold for the national authorities, a lower threshold, if you like, from the international law point of view. We look into it more closely. The national authorities have to show very clearly that this is not a question of getting at somebody else for their exercise of their human rights. And then in the business context, this is now something which is coming in, for instance, international investment treaty arbitration, and in all these mechanisms that you see that being a business person is something which, in this new international economic climate, you risk your local competitor going to their own authorities and with allegations, and then a friendly national authority who then assists you. And now, how is this going to be dealt with by the UN in the future? Now, of course, human rights people are very enthusiasts, or people who deal with this field are very concerned with the traditional human rights violations, the political prisoner, the civil society activist, the journalist. Press freedom is hugely important and is taken very seriously. So, who is the business person in this? It's not something you naturally are that concerned with. This is a wealthy person who can buy good lawyers and all that. But the point is just that if you're going to have an international rule of law, well, this is now the area where the worst transgressions are happening, in a time perspective. This is the new area where it happens, and I wouldn't say the worst in the sense there are terrible things in the political sense, in these traditional areas, but it's the new area. It's the area which has come up, and I think mainly because the other legal systems you have in action here, you know, national administrative law, the commercial law before courts, that in these contexts, these systems are getting better. So that if you are the local competitor, you can't so easily go to a court in a civil case and expect them to help you. You can't get the authorities to discriminate in your favor. So then this becomes a new way of winning in this competition. And that's why it is important to take it seriously, and that's why one has to bring cases before these international bodies.
But in these cases, there has to be really external pressure, doesn't there? And this is why it's so like other forms of human rights issues. It's going to be quite difficult to get pressure building up inside the country itself. I mean, like in Kuwait in this instance, it's got to be done from outside.
And that's why these bodies are important. You know, is there a way of getting it in for the International Court of Justice? Will the country of citizenship for the person detained, are they willing to bring a case, as in the Diallo case? Is there an investment case to bring before an international investment tribunal? And then you have these other bodies like the UN Human Rights Committee and the Working Group on Arbitrary Detention. And they have dealt with these cases. They are open for it in the sense that they regard it as very important. And what I said about this being a pressure point, if you like, right now, I think that is something which there is a good understanding for. And frankly, the experiences from Venezuela and Cuba have been very important. But it also applies, of course, to regimes of a very, very different kind. This idea of, I can mention two other cases we've had. We had a Belarusian civil society activist. They closed down his association and his bank accounts. So then, what could he then do? Well, he opened a bank account in a neighbor country, and he didn't report it on his tax return. Of course, they imprisoned him and sent him down for a long time. And then the UN and the European Parliament said it was necessary for him to do this if he was going to exercise his rights. So therefore, the authorities could not penalize him the way they could according to the letter of their law. There's a number of corruption cases brought in similar ways, in particular in some of the Central Asian republics, where the Working Group on Arbitrary Detention then says, well, here you have people who are involved in civil society, freedom of expression, critical discourse. You have to show very clearly that in the judgment how this corruption offence was committed, and you can't just have these broad conclusions which they had in these cases. And I think that will apply here too. You'll have a heightened scrutiny, and it means that national authorities or courts will have to justify in a different way. And it was the last point you had. How do you manage then afterwards? And that's when you have a ruling from one of these bodies, you must go on and involve the Human Rights Council and other multilateral mechanisms.
I'm going to turn, thank you, Matt. So I'm going to turn to Cherie. Given this business that it's become almost an instrument in business practice in some countries, how can individuals defend themselves from it? And I ought to add here, and I should have mentioned it earlier, that Marsha's associate Saeed Dashti still in jail. He's a Kuwaiti citizen. I mean, it's going to be really hard for him, isn't it?
Well, certainly for Saeed. I mean, he doesn't have the same benefits that Marsha has of being a Russian citizen, and we know that the Russians take protecting their citizens very seriously, so she has that benefit. Saeed is a Kuwaiti citizen, so he is therefore doesn't have that advantage. But to go back to what Mads was saying, it's a very interesting development, isn't it, when you think normally you talk about human rights and you think of as you say, Amnesty International, you don't think about business people being involved in this. And yet what we are seeing, of course, as international trade develops, is this criminalization of what are essentially commercial disputes. And when you think of how international trade is organized, of course, in many countries these days, if you're wanting to do business, you're encouraged to do business with local partners. Now, this is a perfectly legitimate thing for a country to require, that there is local input. But as we know, in many countries, those local partners also happen to be not just business people, but also politically connected people. And if you come into a country and take the benefit of doing business with a politically connected person, and then you fall out with that politically connected person, well, then I think you may then find out just quite how politically connected they are.
Yes.
Because if they are politically connected, they can then use those political connections to involve the power of the state into what you are doing. And Marcia's case is an example of that. We've seen other cases in our practice just relatively, recently, where similar things have happened in a African country, where our client was engaged with someone who'd actually ironically been the Minister of Justice at one time in that country, and then moved out of that into business. And when they fell out, because he demanded more of his share of the profits, I mean, since he'd been the Minister of Justice and appointed many of the judges, surprise, surprise, our client found himself, fortunately, under house detention, and it took a lot of effort to eventually manage to free him from that. So this, Marcia is not the only example of that. The other, of course, example of where this can happen is, even if you're not involved with a politically connected person, there are, sadly, around the world, as we know, systems that are not as robust in their respect for the rule of law, where judges can be bribed, where prosecutors can be bribed, where the systems of how you assess, and we might hear that in some surprising countries, and I'm sure Francoise will say something about that in a moment, that the systems that the state operate are not necessarily complying with the standards that we would expect on an international level. And if you're in those sort of countries, well, again, you can find commercial disputes can suddenly turn into criminal disputes.
So how do you cope with that?
Well,
what's the battle?
Well, on a personal level, but I think if you're talking about what should a business do, I think firstly, what should a business do when it takes it's doing international trade deals? First of all, I'm afraid you really do need to do your due diligence well. So whether it's do your due diligence about the country system in general, or whether, as I said again, if you're talking about a local partner, always remember that local partner who seems to be the favoured son at the moment, they may remain the favoured son and you fall out with them at your peril, or they cease to be the favoured son because their political party, for one reason or another, falls out of favour, and again, you can become involved in what is essentially an internal political dispute, but you can be used in that way. So do your due diligence very carefully. Make sure you absolutely know what you're getting into. But in addition to that, you have to, prevention is key. Realize that if your executives are detained, this could be a really big problem. I mean, we were lucky in that case. He was detained for 6 months. Marcia's been detained 472 days. When you think not just about the strain on the person and their family, but also the strain on the company. If you're an investor at the moment thinking about doing business in Kuwait, and you want to send one of your executives there, think about, can we be sure that when we send this executive there, they will be safe? And what are the implications for our company in not just the human suffering that involves, but also the effect on our business of having someone in prison in that way. And you're particularly vulnerable, I think, as we've seen recently, in these various tit-for-tat disputes between states. And whatever the rights and wrongs between Huawei and China and America, I mean, there's no doubt, is there, that there's been a tit-for-tat going on there. There are other examples that people here will all know about, where when there's been a dispute where somebody's national is detained, the country will then just arbitrarily go and take the national of the other country. The difficulty is, once you've got somebody in prison, it's not that easy to get them out. And this is what we find, because countries can then hide behind this idea. They'll say, well, I'm very sorry, if you go and see them and say, but now we have to, as you'll understand, and this has been said to me, you'll understand, because the British introduced this system of the separation of powers, that we the executive, we can't possibly interfere with the judiciary. And I can tell you, in many countries, that is absolutely true. But there are other countries where, frankly, that's not really true, but nevertheless, it's a convenient excuse, which is why, of course, looking at other methods of bringing pressure to bear are important. And so there's a bundle of tools that you have to use. There is, of course, as we have been doing, the diplomatic pressure that you can use. There is, beyond that, the pressure that you can use by highlighting these issues and publicizing these issues. And then there are these mechanisms. We meet here, as the Human Rights Council is meeting, where you can use, as you were talking, Mads, about the working group and arbitrary detention. We've also taken Marcia's case to the special rapporteur on the independence of judges and advocates. And of course, in the end, we know that the multinational bodies like this don't necessarily have the teeth. No one's going to send a warship in to enforce these rulings, and countries may or may not observe them, the rulings. But the fact is, by using these multilateral mechanisms, you can engage with a country in a different manner, because countries do care about their reputation in the UN. Kuwait at the moment is President of the Security Council. How can we have a situation with the President of the Security Council, on the one hand, the body that's supposed to uphold the principles of human rights that the UN holds so dear, at the same time be violating those principles against its own national in relation to Saeed, and in relation to a Russian national, a woman who has great associations, including her own son being a US citizen, two members of the Security Council there who have both got a particular interest in this case. So I do think that even without the teeth of a gunboat, the UN mechanisms can be used, and do, in many cases, have successful outcomes. The problem, of course, for the individual and for the companies that are engaged for them is, one, these things take time. Two, these things are expensive. And that is a problem for everyone. I mean, we talked, didn't we, just now about a $65 million bail. I mean, no, that's not bail at all. There's no person, well, very few people in the world who could possibly ever pay a bail of $65 million. So it's just making a mockery of the entire system.
Sure, yeah, I'm going to bring Francois in here, because I think, I mean, the parallels, or the differences and the parallels with the case of Carlos Ghosn in Japan are really interesting, aren't they? I mean, Japan is a country strictly under the rule of law. I mean, a Western seeming society, and yet what's happened to Carlos Ghosn is not altogether horribly different from what happened to Marcia, is it?
Merci beaucoup. Thank you for having invited me, and it's a privilege for me to be here. And first I should say that as a former French official I should not speak English, except with a very strong French accent. So I will do my best for that. And I congratulate the organizers for this event, which I think extremely timely. And let me share with you 2 or 3 remarks inspired by your question. First, I believe in symbols, and it's very, for me, it's not insignificant to underscore the fact that this meeting happens in a day where, on one hand, there is a human rights session in Geneva, on the other hand, we are at the eve of a new G20 in Japan. And the second remark is that the G20 aims to create a common grammar between the rulers of the world. And we live in a world which never has been as unpredictable as now. And I would like to just to stop on this aspect one second. If you look at the crisis that affects the world today, and especially Europe, with all the consequences, including Brexit, in fact, most of them, a large part of them, have started with the so-called Arab Spring movement. And what was the origin of this movement, which led to the collapse of the regimes in Egypt, in Libya? It started with, and of course, with all the consequences of in Syria and on the European policies. It started in Tunisia, where? In a village in the south of Tunisia. Why? Because a guy who had his carriage and sold fruits and vegetables in the streets had been confiscated his carriage, and he immolated himself. It was in the village of Sidi Bouzid. His name was Mohamed Bouazizi. This started with the confiscation of his business. So I would like to insist on the fact that doing business is a fundamental right. For many, there is a kind of oxymoron. Why do you talk about business and human rights in the same time? And for him, confiscating his business was confiscating his dignity. And there is a way of doing business which goes with accomplishing one's destiny, and it's definitely one of the basic freedom and human rights that one should protect. The second remark I wanted to share with you is that 70 years after the adoption of the Universal Declaration of Human Rights in Paris in December 1948, universality of human rights is setting back. And there are many examples of that. One of the most worrying examples are all the threats over the international jurisdictions and criminal jurisdictions, and also threats on all the treaty mechanism, including the Geneva bodies that aim to monitor human rights. But the other aspect of that, and here I come on our field, is that massive violations of human rights are not the privilege of dictatorships or countries ruled by law. And arbitrary detention could be seen in a lot of developed countries, and you are right, they are a part of the grammar of all the countries, including the most sophisticated and developed one. What I've seen in Japan is absolutely outrageous. I've seen the whole set, the whole panorama of the violations of human rights, and that makes a detention arbitrary. It's hardly to believe that in a country which, in the eyes of many, is the empire of respect, it's hardly to believe that it could be seen as the archipelago of arbitrary. When my client has been arrested, his arrestation has been orchestrated by the prosecutor. It was a show. The journalists were there. it was a trap, and it was a show. He has been held in custody. In Japan, custody is 23 days, whereas in most of other countries it's 1 or 2 days. 23 days without possibility to have the lawyer. And at the end of the 23 days, they rearrest you again, because it's not enough, for the same facts, but for another period. It's at exactly that if you go too fast on the road, on the highway, the police arrest you, they fine you, and when you are ready to turn the key and start again, they say, okay, now we are going to refine you because the next kilometer you were also driving too fast. It's exactly how it happened, and he has been rearrested 4 times. 130 days of detention, with the light, night and day, without...
That's torture.
That's torture. And you know, the Japanese lawyers generally are very moderate and respectful. And they wrote to the judge saying, stop torturing our client. And I agree with you, that's torture. 2 showers a day, no watch, so you lose completely the notion of time. He was not allowed to walk, and this, you know, having a daily walk belongs to, is a part of what we call in our grammar Mandela rules, the standard minimal rules for prisoners. And he had only half an hour, and during the weekends and holidays, no work at all. So it could happen 4, 5, 6 days without getting out of his small cell. He was obliged to lie down after 9 p.m., forbidden to read, forbidden to write. So this is extremely severe condition of detention. And after that, he has been also rearrested, and he is in a now situation of a so-called bail, which in many ways is a prison again, because without any reason, without any motivation, and without any limit of time, he's forbidden to have any contact with his wife, even telephone contact.
Can I just interrupt you, Francois? We've been talking about the case in Kuwait, where it's clear that external pressure is having an effect, an important effect. It sounds to me, and from my own knowledge of Japan, it sounds to me as though external pressure might actually work against the prisoner.
It's always a very sensitive issue, but I would say that, as Sherry said, and I phrase it with my words, in the today's world, countries are like brands. And brands that comes with values and image. And at one point they take care of their image in this global village. And I think that's very important for Japan. I noticed that just 2 or 3 days after we announced that we will file a petition to the Arbitrary Detention Working Group in Geneva, he has been bailed. So I do think that the fact that the judges they know that they are watched, that's very important. They know that they cannot do their business as usual. They are watched. And you know, Carlos Ghosn is a businessman, and he's seen in the eyes of many as a rich one. It's not that common that major NGOs like Human Rights Watch Japan, FIDH Japan, for example, issues statements and petitions signed by 1,000 lawyers in order to support him and to put an end to what they call a hostage justice system, a system which is completely dedicated to humiliate the person in order to get confessions. You know, human rights are supposed to be universal, but violations are universal as well. And I think that I fear that we entered an era and a world where the seek for fair conscience has taken the place of the seek for truth.
Francois, I'm sorry, I'm going to interrupt you if I may.
Please.
And we'll come back. And I want to ask Randa about the American perspective on all of this. I mean, so often you read in the papers accusations about the way that the US government, especially at the moment, is dealing with individual people's cases and groups of people's cases. But tell me about how these cases, the Goen case, the case of Marcia, are regarded in the US and what it can do about them.
Sure. So first, thank you, John, and thank you all for being here. I'm here to bring the U.S. perspective and talk a little bit about some of the tools in our toolbox in the United States. 4 primary tools, one I'm going to drill down on because it's been very effective. One is, of course, diplomatic discussions, whether they're bilateral discussions or multilateral with respect to the UN. Like Cherie mentioned, the U.S. first choice would be to have some sort of diplomatic discussion if there was an arbitrary detention of a U.S. citizen or an individual that had U.S. links or interests to it, what we call a U.S. nexus. The second and very effective tool that I'm going to talk a little bit about is sanctions, economic sanctions and financial sanctions against a particular abuser or a country. The third tool is an extradition treaty. In the case of an individual that's been accused of a crime, the U.S. oftentimes will negotiate through an extradition treaty to bring that individual back home. And in the fourth case, in very extreme circumstances, the U.S. will enter through force and remove the individual from that particular situation. That is used in very, very small cases, but the U.S. doesn't hesitate to use that if they think that it rises to that level. As I mentioned, one of the most effective tools the U.S. has used recently, and I'll give you some examples, are sanctions. There is one particular law that was passed in 2012 that had been globalized in 2016. So in 2012, Congress passed something called the Magnitsky Act, which applied to a specific case. We globalized it in the U.S. Congress, and it was signed into law in 2016, called the Global Magnitsky Act. I will refer to that as the GMA Act. And what this basically does, it allows our Treasury Department to impose both immigration restrictions and financial restrictions on both human rights violations and allegations of corruption. This law is very broad, so the definition of those abuses can be run the gamut, literally. The U.S. has actually used the GMA law since 2016 quite successfully. I'll give you two specific cases, of course, the murder of Jamal Khashoggi, which I'm sure everyone is familiar with. The United States put many of the individuals who were personally responsible for that murder on our sanctions list. So the individuals through the Global Magnitsky Act were put on the U.S. Department of Treasury list. They cannot come to the United States, nor can they have any financial transaction that deals with the United States. Now you may say, they don't have money in the U.S. Yes, but if they would like to do transactions in the United States dollar, that transaction will have to go through a U.S. bank, and it will be blocked immediately. It has also been quite effective, and we have many cases, but I wanted to talk about some of the more positive ones with our allies, of which Kuwait is, and I think we'll talk about the Marcia Lazareva case, but with respect to Turkey, as you may have known, there was a Christian pastor named Andrew Brunson held in Turkey, similarly arbitrarily detained. The United States used the Global Magnitsky Act to put 2 Turkish officials on that list, blocking both visa and financial sanctions. They released the pastor, and as a result of that, the U.S. took those individuals off of that list. So there are many other examples, but that, for us in the United States, has actually been quite effective. I know there are some other countries that have mirrored this type of law. If I can, because I have been intimately involved, along with Cherie and our team in the United States, on the Marcia Lazareva case. Many of you may ask why. What's the U.S. interest in this particular case? Well, with respect to Marcia Lazareva, she is a Russian citizen who happened to have a U.S. green card that ended up lapsing because of that arbitrary detention. This is a case in which the US and Russian authorities are working in tandem on this case because of dual interests here. Secondly, Marcia has a US citizen mother and a US citizen child. She spent time in the United States and was educated and got her business degree at the prestigious Wharton School in Pennsylvania. So there lies some of the US nexus. Second nexus, and not unimportant, is that Kuwait is an ally of the United States, and quite a strong one. Many of you may remember the United States led the coalition forces for Gulf War in the 1990s, put together by President George H.W. Bush, and we literally saved Kuwait from the invasion of Iraq by putting together an international coalition. And so Kuwait is an ally, and we have a great deal of interest in making sure our allies don't violate the rights of citizens wherever they are. The third, and what I would say is most importantly, is that Marcia Lazareva's business is connected to a logistics firm, a business interest in Kuwait that actually has US Department of Defense contracts. So there are companies in Kuwait that actually are contracted by our Department of Defense to move goods and services. And particularly now, in this heightened region that we have, there are tensions that are quite high. It's highly important for the US government, particularly our Department of Defense, to be able to move goods and services in the region. And Kuwait and the ports in Kuwait are highly, highly important to the United States. And so that's the US interest in this particular case. Certainly, knowing what we know, we believe that Marcia and her colleague Saeed were arbitrarily detained based upon a business dispute, that they were collateral damage as a result of this. But it has risen to the level where there has been inquiries by a member of Congress to the Treasury Department utilizing the GMA, the Global Magnitsky Act. There are several more inquiries about to occur. The President of the United States, I was there at the meeting, has been briefed on this matter, and he was incredibly engaged in asking questions. The Secretary of State has been briefed on this matter, as well as other executive branch officials. So you have our executive branch and our legislative branch incredibly involved in this. Again, there is a strong US national security interest in this. So I would say, with respect to all the tools we can use in the US, the GMA has proven effective in this particular case, and I think in other cases as well. If the Treasury Department decides to implement this GMA trigger, then those individuals named in Kuwait who are intimately involved in the imprisonment and arbitrary detention of both Marcia and Saeed will go on that sanctions list, and again, will be prevented from entering the United States and doing any transactions utilizing the US dollar.
Isn't it, though? I mean, it's up to, as it were, the whim of the US government. We're not talking about a global defense of people to carry out business under proper conditions. We're talking about individuals whom the US has some sort of specific interest in that it gets involved with.
Well, yes. Look, I mean, this isn't sort of at the whim of the Treasury Department. There is an investigation that goes on. So if GMA is triggered, in other words, if there is a request for an investigation into these individuals, the Department of Treasury functions very much like a legal body. So General Counsel reviews the material, and the material comes from credible sources, both on the ground, intelligence sources, our law enforcement sources, and other sources. And there are memos that are conducted, investigations within Treasury, utilizing the advice from the White House, from the National Security Council, from the State Department. Once that decision is made that yes, indeed, this is a credible allegation and these individuals credibly are arbitrarily detaining these individuals based upon human rights violations or corruption, then the orders are issued. Now, what's interesting about the mechanism is, as you might have seen, those sanctions are issued without any public warning. Why? Because we want to be able to catch their money wherever it is, and we want to be able to stop them in their tracks. So you're not going to see any warning when this happens, no publicity whatsoever. You will wake up one morning and see those individuals on the list.
Okay.
I
Does
was
anybody-
going to say,
Sorry,
can I
yes.
just say a little thing about Marcia and why we're so convinced, by the way, that this is arbitrary detention? Because obviously, you know, how do we know, why are we so convinced that, in fact, this is not a fair charge against her? I think we can point to three things, one of which has already been pointed out. The fact is, one of the basic documents used against her has been found to be forged. So the claim
Found by a Kuwaiti court.
found by a Kuwaiti court, and the person from that audit department who produced that document was sentenced to 6 months imprisonment, a bit of a contrast to the 10 years hard labour, but 6 months imprisonment for forging those documents. He hasn't served that because he has absconded. That's one thing. The second thing is that at the same time as the criminal charges were going on, because this is a dispute about whether some bills were owing that Marcia's company had rendered to the Kuwaiti Port Authority, there's been a civil case in Kuwait. And in the civil courts in Kuwait, the courts have ruled that that money was in fact due and owing, and have ordered the Kuwaiti Port Authority to pay those bills. And that case has also gone on appeal, and the appeal court has upheld that decision. So once again, you have the civil courts, which have actually a lesser standard of proof than the criminal courts, saying that this is a fair bill, and you've got the prosecutor alleging that this forged document is in fact a false and is on the basis of a false contract. The two things, just on those bases alone, do not marry up, and therefore, you know, you can say with confidence there's lots of other things that we have produced, but even just looking at those two things, you can see that this case is arbitrary in the extreme. And so that's why we are feeling so strongly that we have to raise this matter and give it the international attention that it deserves, and also to give a warning to those others who are thinking of investing in Kuwait that they may have thought that the system was robust. And to be fair, the civil courts have been robust, but it isn't always the case in the criminal courts.
Does anybody have any questions of our distinguished panel? I should have warned you beforehand, then you can think about it.
If I can just, while everyone's thinking, follow
Yes.
up quickly. In our discussions with Kuwaiti officials, when we initially started working on this case, their response to us was, please don't interfere in our judicial system. We don't interfere in yours here in the United States. While that's honorable, what happens if your judicial system isn't working? What happens, like Shuri said, if your judicial system has huge holes in it? What happens if your judicial system is susceptible to corruption? And that's kind of, I think, where we are right now. I'm sorry.
Alexei, did you?
Yeah, just you, Max, and you, Sherry, both mentioned importance of United Nations committees, different committees of United Nations, and probably about the high efficiency in such kind of the issues. About 3 weeks ago, on the first day of presidency of Kuwait, I asked Minister of Foreign Affairs of Kuwait, which visited United Nations headquarters in New York, and permanent representative of Kuwait to the United Nations regarding about Marcia's case. And response is it's a humanitarian question. A specific person or specific case or detention of the person in, let's say, our country and in Kuwait is not the issue, is not the topic of the United Nations. So why you believe that importance and efficiency of the United Nations can be predicted in that case too?
Well, of course, and it's not the business of the United Nations to go into the courts in any country and dictate or explore how those courts operate in an individual case. But it is the business of the United Nations, and it is the business of the countries who signed up to the United Nations treaties and protocols to ensure that they honour their obligations. And those obligations in particular in Marsha's case, and in relation to arbitrary detention and the requirements to ensure, because one of the worst things the state can do to you, of course, is take away your liberty. And so we have always had, from going back to Magna Carta, the idea of the only way that can be done is if due process is observed. And as well as observing due process, one of the other fundamental positions is that a person is innocent. There's a presumption of innocence. And I go back to what I just said about the contradiction here. You can't have a civil case where they say these documents, this amount was due, and then at the same time say this amount is not due in the criminal case. I mean, there's a real tension there, which leads us to say that the Kuwaiti system is not working in this case. Is that a symptom of something bigger, or is this just an aberration? I mean, to some extent, we wait to see what Kuwait responds to our complaint to see how they would classify this.
François?
Yes, listening to you, I realize that there is also another common point between our cases. I often hear the criticisms of, or the question of those who don't understand why do we defend persons who are seen as rich and powerful. And there is a kind in the human rights community of reluctance to deal with these cases, and we have to address this reality. And I have to say very simply that there are some difficulty to see these cases as human rights cases. And first, I would say that no one is rich nor powerful when you are at the bottom of its jail without free access and capacity to defend yourself. And the second thing I would like to say is that if we do not defend those who are in the light of medias, why would we defend the principles for those who have not this privilege and whom fate doesn't interest anyone? And I don't want to live in an era where the principle of presumption of innocence would be replaced by no smoke without fire.
Yes. Yes, 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 yes. Anybody else? Any other questions? I mean, one of the things, as an outsider to both these major cases, the Golden case and Marsha's case, it seems to me fairly clear, I'd like everybody's opinion on this, that Marsha probably will be okay, because Kuwait is a country that we can, well, if you like to put it this way, bully, or at least we can certainly put a lot of pressure on Kuwait. Whereas Carlos Ghosn, I would have thought, is not quite so optimistic.
Yes, but in Japan, you have a community of human rights defenders who see this case as an opportunity to put the spotlight on a system that they contest and they challenge for many years. I remember when I was in charge of human rights in the French Forest Service, I will never forget the visit of a Japanese lawyer. She told me exactly how she described me this hostage justice system, and she told me how it happened, the executions, because death penalty is applied by Japan, and they hang people in the prison where Carlos Ghosn was detained. And this, when the Minister of Justice of Japan has organized a media show of the prison last week, showing how clean it was, they forgot to show where people were executed. And they forgot to say that the families of the victims of death penalty, they have to pay the rope to get back the bodies. This is how it works.
Well, I would take issue with saying that we can bully Kuwait. Kuwait is a sovereign nation and is a
but you know what I mean.
No, but
it's
a
lot of pressure on it.
Respectable member of the UN, and I would hope that its reputation matters to it, and that this is not a systematic problem with Kuwait, but actually is a problem which can be solved by allowing the system to work properly. And hopefully that is what we will see in Marcia's case, that the system will work properly with a little help from its friends pointing out where perhaps the system has fallen down at the moment.
So, of course, the UN, most likely, none of these UN bodies would say, this is our analysis of the case, this is the rights and wrongs in full. They just look at what were the procedural guarantees which Kuwait is in breach of here. And there are many. And then the consequence of just one or two of these breaches is that the detention is arbitrary and that she should be released. So there's many climb downs, many ways around for a country which would get out of this without losing face. But then you think about the Japan case. So it's clear that Japan has been very worried about international review when it comes to pre-trial detention. They have what we in many of our countries had 30 or 40 years ago, where undue pressure has been used. You don't have the right of counsel's advice. You usually are pressed into convictions which the courts then rely on without having a counsel there. You know, things which we regard as absolutely fundamental in most of our countries. Now, Japan has avoided this, and they haven't been able to deal with this domestically. This is about losing face in the international community. And I think that, you said, difficult to put pressure on Japan, yes, but looking at this, I think that will be the worst case scenario for Japan, to get a period with long-term attention before they manage to review and modernize the system. And just very personal, when I was in the working group on arbitrary detention, we really wanted to go to Japan because we saw this as a major problem among the countries, you know, in the Western group with high standards in many other respects. They wouldn't let us in, and they had the most amazing formal argument. So the major argument was that prisoners have a right to privacy, and therefore Japanese law did not allow us to come in. And we said, well, basically you're part of the UN system. Basically you have accepted these kind of peer review mechanisms, you accepted these special procedures. That doesn't stand up. But this just shows that even in the Japan case, there are ways of approaching this which could have an impact on the outcome of the case.
Randa, will the US be taking the same sort of action about Carlos Ghosn, just as bad a case as Marcia is?
You know, I don't know, can't speak for that because I haven't been intimately involved in that. But again, if there is some kind of US nexus there, I'm sure the United States would certainly look at that. We have a very, very open legislative branch that does, you know, talk to individuals and looks at certain cases. With respect to Kuwait, though, I agree. We don't intend at all to bully Kuwait. We have, in the United States, Kuwait's best interest at heart. They are our ally. In fact, we have Neil Bush on our team, the son of President George H.W. Bush, who liberated Kuwait. He only has the best interests in maintaining Kuwait as a place not only for U.S. companies to do business, but the international community. And we certainly welcome Kuwaiti investment in the United States. And we want to keep that. We also are respectful when their justice system works. We want to be respectful of that, and we were told to please be respectful of that. There is a certain amount of face saving that needs to happen. But while we see what is going on there, we also see glimmers of hope. For instance, the reversal of certain convictions, the forgery cases that have come through. What I think may be happening is that Kuwait now needs to unravel this case. Also on our team is the former FBI director, the Federal Bureau of Investigation Director, Louis Freeh, who has actually gone to Kuwait 4 times. In the most recent visit testified in front of the court, but has looked at the evidence and what has been presented as credible evidence, and it has come back as not very credible. So we're trying to help Kuwait and encourage them along on this case. Don't do this, because it will impact investment both ways, bilaterally as well.
And we have, of course, seen a change in the judge as well. There was this extraordinary position where the judge in the appeal court first dealt with the case, then recused himself, said, oh, I can't deal with it, then within 3 days had unrecused himself, and now he has taken early retirement.
Oh, really?
Yes.
That's it.
Hard to keep track.
Did somebody...
There was a gentleman over there who wanted to ask
Yes. Hi.
I have a question regarding the presence of foreigners in the domestic system. Even all countries, very respectable countries and rule of law obedient countries have long feet when it comes to have foreigners challenging their national justice system. I've been visiting prisons all over the world, so I know what it means to be a foreigner in Kuwait, for example. So, how would you see your position and status being accused of interference in domestic affairs and, for example, using local forces, local lawyers and local activists to, let's say, diminish a bit the image of foreigners lecturing third world countries.
Yeah,
at the end of the day, it's that.
Yeah, this is definitely not about foreigners lecturing. In fact, we have an amazing team of local lawyers who have been handling this case. The problem we've had, however, is even one of our local lawyers has been, in fact, gone through a court process and charged himself. Now, the case in the end was dropped, but he still has that threat hanging over him. It was definitely a warning, and that is, of course, concerning. But in the end, I am not a Kuwaiti lawyer. I do not know the details of Kuwaiti criminal law. But, we do know certain things, that a document is either a forgery or it's not. And you can't, the fact is that the documents that they were relying on and saying she produced these false documents, those false documents she was alleged to have produced turned out to be forgeries themselves. So, that is a huge blow to the prosecution case. And indeed, one questions whether a prosecutor should be continuing with such a case in those circumstances, and it's certainly no failure of a prosecution system for a prosecutor to decide, in the light of the new evidence that's come about, that actually we no longer have evidence that meets the standard of the criminal burden of proof, that somebody has to be proven to be guilty because they are presumed to be innocent.
Can we just have one last question, sir?
Yes. Good afternoon. My name is Carlos Lopez. I work for the International Commission of Jurists here in Geneva. So, just to follow up on your comment, Francois, I want to sort of say the honor of human rights organizations based in Geneva. It's a first comment and then a question as well. There is no reluctance of a human rights organization of taking up this kind of cases, not on principle. On matter of principles, we are very clear, and I personally, in many cases, I have raised my voice to make the argument in the UN debates that human rights belong to everybody. If we defend those who are suspected of terrorism, why we shouldn't defend also those businessmen who are suspected of any other crime? There are a big difference, no? I'm sorry for drawing the comparison there. But the question is about priorities and resources. And I myself spend my time helping lawyers and groups that have cases against businesses, actually, because they argue their rights have been violated by business operations, in the belief and the assumption that these people are the ones who are most in need. Those are the ones who are not going to have any defense, etc. Whereas the businessmen may have more resources to procure themselves the necessary defense they need. So that's what I wanted to say. It's no reluctance on the matter of principles, a question of priorities, etc. But then, that being said, I am sympathetic, I have to say, with the cases you presented. Now, I understand the issues. We will lend definitely any support we can do to those cases and fight for the rights of these people who are being arbitrarily detained. Once the committee or the arbitrary detention working group has determined that such is the case. No? First, we need an international independent determination of the matter. But I have seen many other cases also similar to this coming to my knowledge in Africa in particular, and against mining companies, executives, etc. Is that a wave? My question is, you have better knowledge than me about it. You strategic trends out there. Is there a trend, a wave internationally, especially in developing countries, of some sort of taking back powers and control over the economy, so to speak, the foreign investors in particular? This is just a means to do
I think that it's quite interesting. For example, at the moment, we recently had a case involving Tanzania. And in Tanzania, there was a commercial dispute, and our CFO of our commercial client went to Tanzania to discuss with the business rival, if you like, what could be done, and found himself detained. He hadn't even been in Tanzania until he came to this, and found himself detained. Was it 5-7 days, kept in detention? And you may or may not know that there has been a change in Tanzania following the change of president, and a series of hostile remarks about foreign investors, particularly in things like the extractive industry. And we know, of course, Tanzania has gold, it has precious metals, and a feeling of hostility to those who come into the country to help develop those materials. And that's, of course, why in international trade generally we do have this whole system of Mads talked about it earlier, of bilateral and multilateral investment treaties. And what's interesting to me is to see a different trend. For a long time, these international trade disputes and international investment treaties were seen as the preserve of commercial lawyers. I can remember 10 years ago going to attend an ICSID event in the World Bank, and I was talking about business and human rights and those principles in relation to the commercial law. And one of my friends who's a commercial lawyer coming up to me and saying, "Oh, sure, it's so nice to see someone from another discipline coming to talk to us." And I started my speech by saying, this is not another discipline. Commercial lawyers, as all lawyers, have to be aware of and respect and promote human rights. And so I think what we're seeing is, as and you will know, I know you do know, and under the international treaties, you have certain principles of fair and equitable treatment, non-expropriation. There are principles in relation to these things that are already expressed in the international treaties, and what we're seeing is a developing jurisprudence and an overlap between how these commercial actors also have that duty to respect human rights. And the whole question, and we know about the Ruggie principles, which is the whole question of how do we ensure that we understand that human rights aren't just about governments, and they aren't just about the criminal law. They actually are about, as well, how commercial entities and commercial people operate. And that's why we see we need a mechanism as well for communities whose lands are indeed polluted perhaps by bad business practices, feeling that they too have a voice and a place in this system.
If I may add a comment, I think that's a very profound remark that you made, and I often thought that foreign investment policies sometimes they are the new battlefield for an independence war or emancipation war. And what we can see in many countries is this kind of it's a new battlefield for reasserting independence and self-determination, and some individuals are the victims of that. Yeah. Your question regarding the priorities is also extremely profound, and when we deal with human rights, we always have to deal with the dilemma of priorities. You said that one should prioritize between those who are in the need and those who are less in the need. I think, but also one should prioritize between causes. Are the women more priority compared to torture? Is torture priority compared to a child situation? When I was in charge of human rights in French Foreign Action, I had to deal with that. Do we have to set priorities in terms of geography, in terms of themes, as we cannot be universal, we cannot be everywhere on are the cause of journalists in prison, is this cause a priority compared to others? So this is very sensitive, and as I said, if we do not defend the principles when they are visibly violated, even if the victims are people who are supposedly rich and famous, we are in the light of media, why should we do so for those whom fate doesn't interest anyone?
Francois, I'm going to just bring in Mads to give us a concluding remark.
So, to follow up what Sherry said, of course, foreign business people commit crimes in many countries. There should be no immunity for them. And extractive industries in some of these countries are good examples of that. But what we are talking about, I think, have been a kind of common concern for us, is that you continue business through criminal law, and that authorities assist a business partner or an opponent in business by using arbitrary detention. And that's the concern which is increasing and which is a very serious concern.
Well, thank you very much to 4 superb panelists. I'm very grateful to you. I think now is the time. I was asked to give a little summation. We don't need it. When you've had a panel of lawyers and journalists talking, there's no shortage of words. So I'm going to just hand over to Cherie. I think you're going to invite us all to
yes.
a quick
I don't know about the rest of you, but I'm actually both thirsty and hungry.
Yes.
And it's very hot, so let's go and